It is my pleasure to welcome back to Chicago Kent Rick Hasen. Rick actually began his legal academic career here at Chicago Kent. Is that right? So it's a great pleasure to have him back today. Rick Hasen is Chancellor's Professor of Law and Political Science at University of California, Irvine. He is one of the leading election law scholars, co-author of one of the leading election law casebooks, as well as he's the person who runs one of the go-to resources in the area of the election law. He is widely published, a leading figure for commentary not only on election law, but also on the Supreme Court, which is why we thought when Carol and I were putting together this conference on American politics and the Supreme Court, both of us immediately thought, how great would it be if we could get Rick Hasen here to give his keynote address. Kindly, he agreed to come, so he was sort of the linchpin alongside our visitor from yesterday. We'll say you're two linchpins for the conference today. Rick has a forthcoming book on, title of the book is The Justice of Contradictions, Antonin Scalia and the Politics of Disruption, which will be coming Yale University Press in March of this coming year. And he kindly pulled off some, not material from the book, but sort of a spin-off project in order to talk, which he's going to talk to us today. So with no further ado, I'm going to welcome Rick. He's going to speak for about 30 minutes, and then we'll have about 20 minutes for discussion Q&A following that, and then we will reconvene downstairs at 1:45. Thank you, Rick.
Thanks to Chris and Carolyn for the invitation. And it's great to see some old friends in the audience. It's really a pleasure. It's always a pleasure to talk about law and politics, but it's really a pleasure to be back here today. It's my first time walking back into this building since 1997. My first teaching job, made some good friends, got my academic career going, had some wonderful students, some of whom I'm still in touch with, and I learned so much. I don't miss the interminable Chicago winters, but I do miss the intelligence and warmth of this place. So my talk is about 20 minutes long based on how I usually talk, but I've been told that I talk too fast, so I think it will be more like 30 minutes if I didn't slow myself down. This thing works. So in June of 2013, near the end of the Supreme Court's 2012 term, the court decided two cases of great national significance. In one case, United States versus Windsor, the Supreme Court struck down as unconstitutional a portion of the Federal Defense of Marriage Act, which aimed at limiting the rights of same-sex couples under federal law. It was a ruling presaging the Obergefell case in 2015, in which the Supreme Court recognized the right of same-sex couples to marry. Justice Antonin Scalia dissented in Windsor. He protested that the court had, quote, no power under the Constitution to invalidate this democratically adopted legislation. To Justice Scalia, the majority's due process and equal protection analysis was especially wrong-headed in its failure to defer to the will of the American people, as expressed through the representatives in Congress. Justice Scalia's statement in Windsor was rich in irony because it came only a day after he joined a Supreme Court majority in Shelby County versus Holder, a case striking down a key portion of the Federal Voting Rights Act. The stricken part of the act singled out states with a history of racial discrimination in voting that had to get federal approval or preclearance before making any changes to their voting rules, and to prove that the proposed changes would not make minority voters worse off. In Shelby County, the court, in a 5-4 decision, struck down part of the law that Congress enacted in 1965, and which large bipartisan congressional majorities had repeatedly renewed and expanded. What's worse, the constitutional theory relied upon by the majority in Shelby County that preclearance deprived covered states of their, quote, equal sovereignty was new and hardly inevitable. Why did Justice Scalia believe in deference to the democratic processes in one case, but not in the other? He gave us a clue in the oral argument in the Shelby County case. Justice Scalia was disagreeing with Solicitor General Donald Verrilli's suggestion that Congress was entitled to make a judgment that continued racial problems justified the continuation of the preclearance portion of the Act. And Justice Scalia, this is from oral argument, he said, well, maybe he was making that judgment, Mr. Verrilli. The problem here, however, is that the initial enactment of this legislation, in a time when the need for it was so much more abundantly clear in the Senate, it was double digits against it. And that was only a 5-year term. Then it was reenacted 5 years later, again for a 5-year term, double digits again in the Senate. And it was reenacted for 7 years, single digits against, then enacted for 25 years, 8 Senate votes against, and this last enactment, not a single vote in the Senate against it. And the House is pretty much the same. Now, I don't think it's attributable to the fact that it's so clear now that we need this. It's attributable, very likely attributable, to a phenomenon that's called perpetuation of racial entitlement. It's been written about. Whenever a society adopts racial entitlements, it's very difficult to get them out through the normal political processes. Even the name of it is wonderful, the Voting Rights Act. Who's going to vote against that in the future? In 2009, when the court first considered the constitutionality of the renewal of the 2006 Voting Rights Act, in a case called No, Justice Scalia also remarked in oral argument on the Senate's 98-0 approval of the law. The justice said, the Israeli Supreme Court, the Sanhedrin, used to have a rule that if the death penalty was pronounced unanimously, it was invalid, because there must be something wrong there. He asked counsel whether he really thought any incumbent would vote against the Voting Rights Act. The Sanhedrin remark caught the attention of New York Times reporter Adam Liptak, who dryly noted that Justice Scalia was not announcing the universal principle. Indeed, he almost certainly doesn't think that every unanimous legislative act is problematic. In 1986, for instance, the Senate approved Justice Scalia's nomination to the Supreme Court by a vote of 98-0. It was not just race where Justice Scalia saw what he considered to be special interests messing with the, quote, normal democratic processes and thereby obviating the need for judicial deference. So too, Justice Scalia made this point on the question of gay rights. In the 1996 case, Romer versus Evans, the court struck down a voter-initiated state constitutional amendment in Colorado repealing laws barring discrimination against gays, lesbians, and bisexuals. The court held that the amendment violated the 14th Amendment's Equal Protection Clause by denying them certain legal protection without rational basis. Justice Scalia issued a vehement dissent, rejecting the majority's conclusion that the law was motivated by anti-gay animus. The justice again pointed to supposed defects in the political process. He wrote, relying on certain stereotypes of gays and lesbians, that, quote, the problem, a problem that is for those who wish to retain social disapprobation of homosexuality, is that because of those who engage in homosexual conduct tend to reside in disproportionate numbers in certain communities, have high disposable income, and of course care about homosexual rights issues much more ardently than the public at large, they possess political power much greater than their numbers, both locally and statewide. Quite understandably, they devote this political power not merely to a grudging social toleration, but to full social acceptance of homosexuality. Justice Scalia's shifting deference to democratic procedures and the political process might be no more than rhetorical flourishes, offered in opinions applying neutral principles to determine the proper scope of the Constitution's Equal Protection Clause. Notes about democratic dysfunction might provide nothing more than what Justice Elena Kagan once described in a different context as extra icing on a cake already frosted. Or the shifting deference might provide a window into Justice Scalia's decision-making, explaining part of the reason for the justice's hostility to race-based affirmative action, voting rights cases, and gay rights legislation. Perhaps he viewed these laws as part of a dysfunctional political process, although he never explained why some organizing for political action was somehow more objectionable than others. In this address, I want to consider through the lens of Justice Scalia's opinions the role that the political process plays, at least rhetorically, in how the Supreme Court justices decide cases. I will focus on Justice Scalia's contradictory views on self-dealing and incumbency protection across a range of cases, comparing campaign finance cases on the one hand to partisan gerrymandering, voter identification laws, political patronage, and ballot access rules on the other. In this context, I will argue that the defects in the political process that he sometimes flagged appear to do little work, and that his decisions are better understood by his ideological commitments to what Chicago Kent Professor Steve Heyman, sitting back there, calls conservative libertarianism. And I guess I won't be, when I give this talk elsewhere, I won't be able to do that. The discussion draws and expands upon the ideas in my forthcoming book, The Justice of Contradictions, Antonin Scalia and the Politics of Disruption. I use Justice Scalia as an example in this address, not because he was necessarily more contradictory in his judging of the political realm than the other justices, but because I've been focusing on him for the last few years as I've been writing this book. So I plan to do three things today. First, I want to describe Justice Scalia's contradictory approaches on the questions of self-dealing and incumbency. Second, I want to argue that the contradictions lined up with his ideological and partisan commitments. And third, which is something hardly unique to Justice Scalia. And third, I want to offer three lessons that can be learned from this case study for the interaction of the courts, the political branches, and election law. So let me start with a description of his contradictory approach on the question of politicians' self-dealing, starting with campaign finance. Oh, so those are my three, missed that, my three points of the outline. So in 2010, the Supreme Court decided Citizens United versus Federal Election Commission, a case which struck down a federal law limiting spending by corporations on candidate political campaigns. The court held that business corporations have a First Amendment right to spend unlimited sums independently in candidate elections, and the case helped to usher in a much looser campaign finance regime in which it's possible for the wealthy to donate millions of dollars to closely aligned super PACs and other groups. It's probably one of the most controversial opinions of the Roberts Court. Citizens United was a vindication for Justices Scalia and Anthony Kennedy, who had supported a First Amendment right of corporations to spend money in elections since they dissented in a 1990 decision, Austin versus Michigan Chamber of Commerce. Austin had upheld the Michigan state campaign finance law barring business corporations from spending money on candidate election ads. The corporation instead could raise money and control a separate political action committee, or PAC. Michigan's law exempted media corporations like corporate-owned newspapers and television stations, which were providing news and commentary. It also did not apply its limits to labor unions, as the parallel federal law did. With Justices Kennedy, O'Connor, and Scalia dissenting, the Supreme Court in Austin upheld Michigan's PAC requirements, although a 1976 case, Buckley versus Vallejo, had held that campaign limits could not be applied against individuals, and contribution limits could only be upheld in order to prevent corruption or the appearance of corruption, which the court in Buckley said was akin to bribery. The Austin court held that Michigan's spending limit was justified to prevent what it termed a, quote, different type of corruption, which it described as the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public support for the corporation's political ideas. Justice Scalia tartly rejected the anti-distortion argument in Austin. He began his dissenting opinion by flagging what he called the censorship allowed by Michigan's law, calling it Orwellian. And a big focus of his dissent was what he viewed as the self-interest of politicians in passing these laws. Scalia wrote that an incumbent politician who says he welcomes full and fair debate is no more to be trusted than the entrenched monopolist who says he welcomes full and fair competition. He further suggested that the reason Michigan regulated the spending of business corporations and not labor unions was because labor unions in Michigan were a powerful political force, making many American automobiles. Unions' political power was somewhat less legitimate to Justice Scalia. Justice Scalia made similar points in other campaign finance cases, emphasizing self-dealing as a reason for striking down these laws. Indeed, the role of incumbency protection took center stage in his partial dissent in the 2003 case, McConnell versus Federal Election Commission. McConnell was a case which reaffirmed Austin and which was later overruled in part in Citizens United. It considered the constitutionality of the Bipartisan Campaign Reform Act of 2002, more commonly known as McCain-Feingold, which reined in soft money and issue ads, which had rendered much of existing federal campaign finance law ineffective. Justice Scalia opened his partial dissent in McConnell, calling it a sad day for freedom of speech, and he raised the incumbency issue. He said, "We are governed by Congress, and this legislation prohibits criticism of members of Congress by those entities most capable of giving such criticism loud voice, national political parties and corporations, both of the commercial and not-for-profit sort. It forbids pre-election criticism of incumbents by corporations, even not-for-profit corporations, and the use of their general funds, and forbids national party use of soft money to fund issue ads that incumbents find so offensive." Justice Scalia's professed concern about incumbency and self-dealing led him to be very skeptical in the campaign finance cases. His writings suggest that the dangers of incumbency and self-dealing provided a reason for extrajudicial scrutiny for laws regulating the political process. And yet, his concern about incumbency and self-dealing did not extend beyond the campaign finance cases. Indeed, in 4 other areas, Justice Scalia either minimized the dangers of self-dealing, professed an inability of courts to handle the problem, or in at least one instance, celebrated political self-interest. So let me start with partisan gerrymandering, which is very much in the news today as the Supreme Court had its argument in Gill versus Whitford, the partisan gerrymandering case out of Wisconsin. It's sometimes said that gerrymandering allows legislators to choose their voters rather than the other way around. When legislators draw district lines to help themselves or their political parties, they sometimes engage in the raw self-dealing imaginable. And the question in Whitford is whether the court will put the brakes on this activity. For a long time, the Supreme Court refused to get involved in these cases, finding them to be non-justiciable political questions without judicially manageable standards. Beginning in Baker versus Carr in 1962, the court allowed some challenges to redistricting, beginning with the one-person, one-vote standard. After cases like Reynolds versus Sims and the passage of the Voting Rights Act, which protected minority voting rights, the court dove right in. Since the 1990s, it has held that taking race too much into account in the drawing of district lines violates the Equal Protection Clause of the Constitution, putting states in the position of navigating between the race-conscious requirements of the Voting Rights Act, and the court created a rule not to take race into account too much for fear of violating the Equal Protection Clause. Even with all these rules in place, politicians have still been able to draw districts which give partisan advantage to one side or another. For example, in ongoing litigation over the congressional districts in North Carolina, the Republican majority legislature recently passed a redistricting plan that creates 10 safe Republican seats and 3 safe Democratic seats, even though the Republican-Democratic split in the state is about even. North Carolina Representative David Lewis, when asked why he drew 10 of the 13 districts as majority Republican, astonishingly replied, quote, "Because I do not believe it is possible to draw a map with 11 Republicans and 2 Democrats." The fight to get the court to rein in such partisan gerrymandering so far has been unsuccessful. In a 1986 case, Davis versus Bandemer, the court agreed that partisan gerrymandering cases were justiciable. However, the Bandemer standard proved uncertain in theory and impossible in fact. For the 18 years after Bandemer, there were no successful partisan gerrymandering claims in any court. The Supreme Court returned to the issue in a 2004 case called Veith versus Drubellerer, involving allegations of partisan gerrymandering, the creation of congressional districts for the state of Pennsylvania. The court divided into 3 groups. Justice Scalia, for the 4 conservative justices, took the position that Bandemer was wrong on the question of justiciability, and that there were no judicially manageable standards for courts to apply. He believed courts were without the power to decide such claims. The 4 liberal justices, in contrast, believed that Bandemer was right, and that these cases were justiciable. But that Bandemer was wrong on the standards, and the dissenters put forth a variety of proposed standards to police gerrymandering. Justice Kennedy, writing for himself alone, stood in the middle, and I think stands in the middle still today. He agreed with the liberals that partisan gerrymandering claims are justiciable, but he agreed with Justice Scalia and the other conservative justices that each of the proposed gerrymandering standards did not separate permissible from impermissible consideration of partisanship in drawing district lines. The result was that the plaintiffs in Veith lost their case, but the door remained open for future challenges. We will see in Whitford if Justice Kennedy has changed his mind about the old standards or found a new standard, such as the efficiency gap standard put forth by Professors Nick Stephanopoulos and Eric McGee. Perhaps the most interesting aspect of Justice Scalia's Veith opinion was his admission that extreme partisan gerrymandering may well be unconstitutional even if the courts don't have the tools to police it. He said, much of Justice Stevens' dissent is addressed to the incompatibility of severe partisan gerrymanders with democratic principles. We do not disagree with this judgment, any more than we disagree with the judgment that it would be unconstitutional for the Senate to employ in impeachment proceedings procedures that are incompatible with its obligation to try impeachments. The issue we have discussed is not whether severe partisan gerrymanders violate the Constitution, but whether it's for the courts to say when a violation has occurred and to design a remedy. Justice Stevens says that we err assuming that politics is an ordinary and lawful motive in redistricting, but all he brings forward to contest that is the argument that an excessive injection of politics is unlawful. So it is, and so does our opinion assume. The discussion was an odd statement of judicial powerlessness coming from Justice Scalia, and it was in tension with Justice Scalia's acceptance within Veith itself of the legitimacy of some partisan self-dealing. Indeed, as Professor Michael Kane recently explained, Justice Scalia's opinion in Veith has been what is most responsible for setting out the idea that taking partisanship into account in drawing district lines is a, quote, ordinary and lawful motive in districting, and that partisan districting is a lawful and common practice. Justice Scalia shifted the discussion to the question of how much of the legal activity crosses the line into illegal activity, and in doing so, he gave wide berth to legislators to engage in self-dealing when drawing district lines. Justice Scalia was similarly unbothered by the use of raw political power in setting the rules for voting itself, fights that I've elsewhere termed the voting wars. In the period since the 2000 election, Republican legislatures have been passing laws making it ever harder to register and to vote, and Democratic legislatures have done the opposite, with both parties believing that such laws might give them at least a small partisan advantage. In one of the first voting wars cases to make it to the Supreme Court, a 2008 case called Crawford versus Marion County Election Board, the court considered the constitutionality of a law from Indiana which required voters to produce one of the few acceptable forms of photographic identification allowed in order to be able to vote. The state of Indiana justified its law as necessary to prevent voter fraud, but the state conceded there were no cases of impersonation fraud recorded in the state, ever. The only kind of fraud that an identification law would prevent. Plaintiffs' counsel had their own problems in the case, having trouble coming up with a single plaintiff who did not have the right identification and had trouble getting one in order to satisfy the law. As in Veith, the court divided into three camps. Justice Stevens, writing for himself, Chief Justice Roberts, and Kennedy upheld the law against a facial challenge. According to Stevens, an identification requirement was only a minor burden for most voters, and the law was justified on anti-fraud and public confidence grounds. Stevens reached this opinion despite the lack of evidence that the law helped on either fraud or public confidence grounds. He had to literally go back to Boss Tweed's day to find examples of the relevant kind of voter fraud, cited in a footnote, and maybe one case in 2004, one vote cast in the gubernatorial election, 2004 in Washington State. But Stevens crucially left open the possibility of follow-on, as-applied lawsuits brought by groups of voters who face significant burdens in getting the free ID. Justice Scalia, writing for himself, Justice Alito, and Justice Thomas, was harsher than Stevens. He agreed the law imposed little burden on most voters and voted to uphold the law. He believed that the law could be applied against everyone, precluding the possibility of as-applied challenges from voters facing special burdens obtaining the right kind of identification. He wrote that, quote, the Indiana photo identification law is a generally applicable non-discriminatory voting regulation, and our precedents refute the view that individual impacts are relevant to determining the severity of the burden it imposes. For Justice Scalia, voters who were born in concentration camps, this is from an actual case in Wisconsin, voters who were born in concentration camps and therefore lacked a birth certificate to get the ID, or who were too poor to afford the $20 fee to buy a birth certificate, needed to prove identity to get a so-called free identification card, would simply be out of luck. The Indiana voter ID law passed on a party line vote, supported only by Republican legislators and opposed by Democratic legislators. Justice Stevens acknowledged the fact but said that because the law also had a nonpartisan basis, that was no reason to strike it down in whole. Justice Scalia's opinion did not even address partisanship. The court allowed the law to go forward despite the legislators' likely partisan motivations and without proof that the law stopped any real fraud or promoted voter confidence. Two more quick examples, which illustrate that Justice Scalia not only tolerated political self-dealing, sometimes he actually praised it. In Rutan versus Republican Party of Illinois, which some of you are probably very familiar with, the court held that patronage, hiring, firing, and transferring of non-policy-making employees violates the First Amendment. After this 1990 case, the state of Illinois could no longer fire a secretary or a security guard for not belonging to the governor's political party or paying party dues. The court held that premising non-policy-making government jobs on political loyalty punished voters for their views protected by the First Amendment. Justice Scalia dissented and thought it was a good idea to give the governor the power to fire, hire, and demote employees based only on partisan affiliation. He believed that patronage-based employment promoted strong political parties by generating loyalty and party funds. Scalia found this interest to be strong enough to override the employee's First Amendment rights, not to be punished for failing to join or belong in another political party. He wrote in dissent, quote, "It may well be that the good government leagues of America were right and that Plunkett, James Michael Curley, and their ilk were wrong, but that is not entirely certain. As the merit principle has been extended and its effects increasingly felt, as the Boss Tweeds, the Tammany Halls, the Pendergast machines, the Bird machines, and the Daily machines have faded to history, we find that political leaders at all levels increasingly complain of the helplessness of elected government, unprotected by party discipline, before the demands of small and cohesive groups." And then there was the case of New York State Board of Elections versus Lopez-Torres. That 2008 case concerned a constitutional challenge to the means by which certain New York trial court judges were nominated by parties and placed on the general election ballot. The record showed that party insiders controlled the nomination process and demanded political patronage in exchange for political support. Party nominees were virtually guaranteed election, Democrats in some parts of New York and Republicans in others. It was possible to qualify for the ballot without being a party nominee in these elections by collecting petition signatures, but these alternative candidates inevitably lost. The Supreme Court unanimously rejected the challenge to New York's party nomination processes for justices, and the justices offered different reasons for reaching this result. But Justice Scalia wrote a broad majority opinion which went much further than necessary to decide the case. He wrote that the Constitution contained no guarantee of a fair shot to win an election. Going even further, he said, quote, "Party conventions with their attendant smoke-filled rooms and domination by party leaders have long been an accepted manner of selecting party candidates. It's hard to think of more self-dealing than the smoke-filled room, but here was Justice Scalia and Lopez-Torres looking back on it nostalgically." Say what you will about Justice Scalia's decisions in the partisan gerrymandering, voting wars, political patronage, and ballot access decisions, but it's hard to say they express great concern about the dangers of incumbency and self-dealing, much less that they suggest reasons for striking down democratically enacted laws. So turning to the second of the three parts of my presentation, what explains Justice Scalia's near obsession with incumbency protection in the campaign finance cases, and his grudging acceptance and sometimes even embrace of self-dealing in other cases? It can't just be that the campaign finance cases are about the First Amendment. That's true too of the patronage cases and some of the other cases as well. Why does limiting six-figure donations from wealthy individuals, corporations, and labor unions smack of self-dealing, while it's unobjectionable to fire the state's janitor who refuses to sign up with the governor's political party and pay party dues? It appears that Justice Scalia's decisions in these cases, like his decisions across many areas of constitutional and statutory law, reflected his conservative libertarian impulses. In the First Amendment context, Professor Hasen describes a conservative libertarian jurisprudential approach which advocates invalidating, quote, "laws or policies that in their views threaten to subordinate individual liberty to liberty or progressive goals, such as political reform, racial and sexual equality, gay rights, secularism, unionization, and anti-smoking efforts." Justice Scalia was firmly in this camp, probably more firmly in this camp than any other justice on the Supreme Court. More generally, Justice Scalia opposed extensive regulation of politics by the courts and expressed dissatisfaction with such interference. except when it came to limiting the role of money in politics or protecting voting rights, especially minority voting rights. Sometimes partisanship was worth screaming about, at other times it was lawful, inevitable, and even a vital tool of democracy. It was his fundamental conservatism, rather than his views of the political process, which seemed to drive most of his jurisprudence. So finally, let me turn to the 3 lessons to be learned from this case study of Justice Scalia and self-dealing. But before I do so, I want to emphasize that Justice Scalia is not unique in letting his ideological views color his jurisprudence. Consider Justice Souter, for example, who was on the opposite side of Justice Scalia in almost all of the cases I've discussed. Souter was much more attuned to partisan self-dealing in the context of gerrymandering and in the voting wars cases than he was in the campaign finance context. Indeed, when it came to campaign finance context, Justice Souter was probably the greatest proponent on the court of the view that campaign finance laws deserve deference because of the special expertise of election officials and the means of campaigns. I'm not sure that was the kind of expertise that would be useful in designing campaign finance laws. Might be useful in staying in office. Justice Scalia afforded no such deference to the expertise of elected officials when they gerrymandered or passed voter ID laws. Okay, so on to the third part of my talk. What lessons can we learn? Lesson number 1. When all else fails, lower your expectations. Back in 2000, my mentor, Dan Lowenstein, wrote a book chapter entitled, "The Supreme Court Has No Theory of Politics, and Be Thankful for Small Favors." Lowenstein's main point was that over-aggressive judicial review in election law cases would simply empower the courts, which had no overarching theory of appropriate political competition, to say how the political process should be regulated. That point is certainly true, but I would go further. The problem is not just that there's a lack of coherence on issues like self-dealing on a multi-member court with shifting constituencies. It's that the justices themselves are not internally consistent, and that they are driven at least in part by an ideology which I'll explain increasingly lines up with partisanship. This means that consistency and adherence to precedent will have only limited value in predicting how Supreme Court justices will choose or not to choose to regulate politics. For a decade, American election law turned on what Justice OConnor had for breakfast. First, the justice supported corporate spending limits in campaigns, then she opposed them, then she supported them again in a First Amendment challenge, and the law moved with Justice O'Connor. Since Justice O'Connor's retirement, it has been Justice Kennedy in the middle, and if he retires, it will be Chief Justice Roberts in the middle. We might as well have had the parties argue Gilby Whitford just to Justice Kennedy and give everybody else the day off. Political scientist Anthony Downs' admonition to focus on the median voter has the greatest currency on the Supreme Court, and these justices are swing justices precisely because their ideology is at least occasionally cross-cutting or tempered by pragmatism. That was less true of justices like Justice Scalia or Justice Souter. Lesson number 2, the Supreme Court is a political court. As we saw when it came to self-dealing and incumbency protection and regulation of the political process, Justice Scalia decided cases in line with this ideology, an ideology which, as I argue more broadly in my book, lines up with a neo-Trumpian, populist, nationalist, conservative libertarianism. Sometimes, and for some justices, that pragmatism can trump ideology. That justices are ideological is nothing new, and this, of course, is not confined to conservative justices, nor is the pragmatism. Think of Justice Brennan, who was a pretty strong liberal, but he tempered his liberalism whenever he needed it to get to 5. What is new and different about the current Supreme Court is all the lining up with ideology and partisan affiliation. Since the retirement of Justice Stevens, all the Supreme Court justices generally considered liberal were nominated by Democratic presidents, and all the justices considered conservatives were nominated by Republican presidents. I don't mean to suggest that justices are, to use Professor Justin Levitt's useful term, tribal partisans. Such partisans, quote, may favor public actions purely because of the policy in question is perceived to benefit those with a shared partisan affiliation, or because the policy in question is perceived to injure partisan opponents, wholly divorced from, or stronger yet, contrary to, the policymaker's conception of the policy or other merits. Few close observers of the court view the justices as tribal partisans. They generally are not voting in particular cases to help out their political party. Although the votes and reasoning of the controversial 2000 case of Bush versus Gore, ending the presidential recount in Florida, pushes against these notions. Rather, it is that these justices were chosen for nomination because their jurisprudential views line up with the interests and ideology of each party. Just think of the early signals from the newest justice, Neil Gorsuch, and where he's likely to end up in these disputed issues. He looks to be deeply conservative on many issues, such as the question of gay rights, perhaps with an independent streak on criminal procedure, much like Justice Scalia. I have every reason to believe that Justice Gorsuch is not voting in a generally conservative way because he is a Republican, or because he wants to help the Republican Party. Rather, he was chosen for his position by a Republican president and Senate because of how he votes. This confluence of ideology and party has two important implications for the Supreme Court in American politics. First, if all the Democratic appointed justices on the court vote the same way in the campaign finance, voting rights, and gerrymandering cases, and all the Republican appointed justices vote the other way, election law cases are bound to become even more politicized than they already are. No more Justices Stevens, Souter, or White crossing party lines. Litigants, too, then, are likely to frame their arguments in partisan ideological terms in a way that they haven't before. Second, and just as importantly, the public and other political branches will begin to see the court as a more partisan institution, and less sophisticated individuals will believe, and cynical politicians across the aisle will push the argument that these justices, in fact, are engaged only in tribal partisanship, voting for the interests of the Republican Party or the Democratic Party. Finally, I turn to lesson number 3. The political branches will respond politically to a political court. In an era of hyperpartisanship, with the lagged realignment I've described on the Supreme Court, the politics of the court will influence how the President and Senate view the court's work. And that, in turn, will influence the court's future composition. The sharp new division, not just ideological, but between parties, goes beyond election law to issues such as abortion rights, gun rights, race, and congressional power. And it explains why we've seen the erosion of norms over judicial nominations, filibusters, and supermajority rules, including the blockade of Merrick Garland, Senate Majority Leader Harry Reid's blowing up of the filibuster for judicial nominations, aside from the Supreme Court, Senate Majority Leader Mitch McConnell's blowing up of the filibuster for Supreme Court nominations, and the party line almost confirmation of Justice Gorsuch, and the soon-to-be demise of the blue slip for federal appeals court nominations. The stakes are starker, and the lines are more clearly drawn, making compromise on judicial nominations much less likely. When Democrats come back into power, it's possible we will see new attempts to pack the court to restore a lost partisan advantage. In sum, we in the United States now face a different confluence of two factors. First, the Supreme Court of the United States has great power over the rules and structure of American elections, from money in politics, to legislative districts, to voting rights, and to the basic question of who gets to exercise the franchise and how hard it is for them to do so. Second, the justices on the court have very different views on constitutional questions about these election rules, views which increasingly line up not only with the ideology of the justices, but also with their apparent partisan affiliations. Before long, if not already, voters will think of the justices in more partisan terms, and in the end, we will have a Democratic Supreme Court or a Republican Supreme Court. This will be especially true if the justices are inconsistent in applying their concepts across cases, as Justice Scalia was, as other justices are, when it comes to the dangers of incumbency protection and partisanship. Incumbency protection was enough to doom the campaign finance laws that Justice Scalia didn't like, but not enough to doom the partisan gerrymandering or biased election administration rules he appeared to like more. The convergence of a court with great power over election rules and an increasing partisan divide between liberal and conservative justices over how to resolve election cases means there will be stress on both the United States electoral system and the legitimacy of the Supreme Court. As election rules shift with shifting Supreme Court majorities, and it becomes harder and harder to avoid seeing justices making political rather than legal decisions. It's a dangerous combination for American democracy. Thank you.
So Rick has kindly agreed to questions. We have about 20 minutes for discussion, so if you'll just call.
Yeah.
So obviously you're critical of ideologically driven decisions at the polls. Justice Scalia is one example. But you also had some critique of the sort of centrist positions that were inconsistent for Justice O'Connor. And I wonder if centrism is an ideology that you actually support in some ways, or is that also a wishy-washy, inconsistent, result-oriented ideology to follow? And if so, what's sort of the ideal position for justices to take? Should they take that centrist view, or should they be on the polls?
So I don't think I'm criticizing Justice O'Connor for being a centrist. I think I criticize her more for taking three positions on the same issue across the years of cases. So in the MCFL case in 1986, she thought that corporate spending limits to prevent distortion of the political process was okay. Then she dissented in Austin. And then when Chief Justice Rehnquist changed his views about Austin in the McConnell case, she switched her view back, preserving a 5-4 majority. So the problem is not centrism, the problem is lack of consistency. But what I'd say is, I think we're entering, more to the point of what should the justices do, I think we're entering into a period where it's inevitable that the justices that are going to be chosen are going to be strongly aligned with the interests of these two hyperpolarized political parties. That is, we're going to have more justices like Justice Gorsuch on the right, and similarly strong liberals on the left, assuming it's unified control and they can get these people through. It'll be different if you have a President Trump and a Democratic Senate. I don't know what happens there. Probably no nomination. But I think the answer to this, it's not unique to me, is 18-year term limits and rotating justices off the court. I think it was Lori tweeted, I said, what questions should we ask Justice Kagan? And she said, how about 18-year term limits? How would you feel about 18-year term limits for new justices if each sitting justice would agree to leave the court in order of seniority every 2 years? And kind of, if it's going to be a political court, inevitably it is going to be a political court, having the change with a lag more reflect public opinion is the least worst way to deal with the inevitable polarization of the Supreme Court. Good.
Yeah, so what's your prediction for the Wisconsin gerrymandering, if that's the word, case in the Supreme Court now?
So after I predicted Hillary Clinton would win election, I'm not at prediction business. I did read I wasn't at Gill. I was teaching, so I would have loved to go see that. But I did read the transcript. Justice Kennedy, near the beginning of the argument, thought that the standing question was a potential good one for Wisconsin. But then otherwise, he had no tough questions, no questions really at all for the plaintiffs. All of the questions were against Wisconsin, the Wisconsin legislature. At one point, his line of argument was, what if you built into the state constitution a requirement that after you've complied with compactness or else, you must favor party X over party Y? Would that be constitutional? And there was some hedging there on that side. It seemed to me that he was moving in that direction. So what's changed between 2004 and 2014? I say two things have changed. One is that gerrymandering has gotten more effective. So it used to be that Justice O'Connor called it in Bandemer a self-limiting enterprise. If you cut the bologna too thin, you are not going to be able to keep your majorities. But now, according to the brief put in by Bernie Groffman and Keith Gaddy, who are really the top redistricting people in the country, you can now, with better data, create an effective gerrymander for the entire decade. And what's going to happen if the court doesn't rein this in, it's not going to look like Wisconsin, it's going to look like North Carolina. They're just going to nakedly engage in partisanship, and if they can draw an 11th out of 13, they will. So that's changed. But the thing that's changed more importantly, it's not the efficiency gap of the legal standards, it's that Justice Kennedy is going to retire, if not this year, next year, the year after. This is really the last chance for him to do, he's been sitting around for 13 years waiting for a standard. If he doesn't act now, this is the last chance. And I think, just like in the gay marriage cases, where who's going to want to be remembered for something, if we're trying to psychoanalyze Justice Kennedy, this is being taped, and probably by the time this airs, I'll be proven wrong. But I would think he would do something But I don't think that's going to be the end of the story, because if the test looks like the one that Justice Breyer suggested in oral argument, which is it's got to be one-party rule, then intent, effect, justification, you can imagine that four-part mushy Breyer-esque test being something that by the time it gets to Chief Justice Roberts as the median justice a few years later, it'll be watered down and whittled away, and it's hard to see how effective it is. There's a great piece by Ned Foley which basically says, how can you, if you're Justice Kennedy, lock something in? And I think he basically concludes, you need a mechanical rule like the one-person, one-vote rule, or it's not going to work. And he says, if it's less compact than the original gerrymander from Elbridge Gerry, I don't know what the standard is. So that's a long answer. I don't know, but if I had to guess, I would think Kennedy's going to do something because it's really the last chance. Yeah.
For those of us who were sitting here yesterday, it's really kind of hard to not see you and
Well, hi.
Hi.
I haven't seen you in 20 years.
To see you in opposition, like almost two sides of the debate, because I'm pretty sure, given what she said twice to us yesterday, that she thought that most members of the court were absolutely acting in good faith, that they agreed more than they disagreed, and that they all, in their own ways, sort of strove to understand the law as law in non-political terms. And so my somewhat harsh question to you is, would you basically just accuse her of false consciousness?
I think, having studied Justice Scalia for the last few years, I think he acted in good faith. And I don't think anything I've described is not acting in good faith. I think this is happening below the consciousness. That is, the incumbency bothers him in a case where he's otherwise disposed for his conservative ideological reasons to want to allow those with wealth to have more influence in politics. So I don't think he's acting in bad faith. I don't think any of them are acting in bad faith, but I do think that they're human beings and they're not always consistent, and they don't have a consistent approach in these cases. They're all somewhat result-oriented. I did see Justice Kagan's talk as, more than anything else, I'm going to have to put this right, demonstrating how politically savvy Justice Kagan is. So when Justice Kagan declares, I have a whole chapter on textualism, and I quote her, we are all textualists now. When Justice Kagan declares that she's a textualist, I think that is and when she goes hunting with Justice Scalia, for those of you who were here last night for the dinner talk, I think that is a signal that she is approachable and is willing to negotiate and is willing to give in on certain cases. So there's this case, the Yates case, this is the case about whether a fish is a tangible object. There's Dodd-Frank law that said if you destroy papers, documents, or other tangible objects, you could be sentenced for this crime. And it was Ginsburg versus Kagan on the question of whether or not is a fish a tangible object. If I'm going to get this right, Justice Ginsburg says that it is not, because you need to use the canons of construction like nos versosus, and it means, or justum generis, the words known by the company it keeps, it applies to financial instruments that are destroyed. And Justice Kagan, this is where she cites Dr. Seuss, one fish, two fish, red fish, blue fish, says, a fish is a tangible object that applies textually. That's a low-stakes case. Nobody really cares. But she gets a lot of credit for being a textualist. And so maybe she can use that credit in the center of the court to get her way more time. So I think, it's different than the Clarence Thomas approach, which says, I've got some principles, and I'm going to decide cases in line with those principles, and if no one comes along with me, I'm fine with that. So I take it that Justice Kagan, consciously or not, is marketing herself as someone who can speak to the conservatives on the court and sometimes get things in response. I see her as kind of a successor to Brennan in that sense. Yeah.
At the end of your talk, you spoke, and I've heard you say this before, about how you think it's a very dangerous thing that the party of the appointing president is now going to line up with the blocks of justices. And I'm really curious why. Because if after like 1982 or 4, did it matter to the kind of public at large that Justice Stevens had been appointed by a Republican president? In other words, if there's not cross-block voting actually happening, why does party of the appointing president matter matter in terms of how we perceive the court's polarization and politicalization?
So I think it goes to legitimacy of the court, which is, as you know better than I do, a hard thing to measure. So just imagine that we had Bush versus Gore too, except it's Trump versus Kamala Harris. And all the Republicans are on one side. It's Kavanaugh has replaced Kennedy in 2020. Right? So it's Kavanaugh, Kennedy, Alito, Thomas, and Gorsuch versus Ginsburg still there. Ginsburg, Breyer, Sotomayor, and Kagan, and they decide, a very close election that could go either way for Trump. Don't you think people are taking to the streets and seeing the Supreme Court's opinion as completely illegitimate in a way that they didn't in Bush versus Gore when you had, I remember like all the argument was, look what Breyer did in saying that there was an equal protection problem, or Souter, it was 7-2, it wasn't 5-4, and there were Republicans on both sides. I think it's fundamentally different when Chuck Schumer can get up there and blame the Republican Supreme Court for things. And so I think that's why I think it's dangerous. People can understand all the Republicans did something in a way that, we talked at the morning panel about how reporting on the Supreme Court is generally not very good. It's going to be more and more seen in partisan terms. And so I think that's going to influence the legitimacy of the court and people's willingness to accept the court as the final arbiter of these things. Yeah.
So are there, as you sort of think about this problem, are there sets of cases where you think it would just be wise as an institutional matter for the court not to intervene? And if so, what kinds of cases would those be?
So when should the court stay out? So back in 2003, I wrote a book called The Supreme Court and Election Law. And I basically said the court needs to protect core voting rights, like no poll taxes. I put the voter ID in this category. But that on contested issues, the court should hang back and wait for emerging social consensus before it acts. And then in 2005, I wrote a piece on Veith where I said basically Justice Kennedy was right, that there was no social consensus. It was really unclear what to do, and the courts need to hang back. I now think, this is why maybe to answer Joan's question, what's Kennedy going to do? Where I've come, I've moved much closer to the position that the court should start reining this in. One of the things that really struck me, there were 30 amicus briefs filed in the Gill case, a number by political scientists, not one on the side of Wisconsin. So there does seem to be a consensus that gerrymandering has gotten worse, and it's measurable enough. One of the points that was made in oral argument by Paul Smith was, there are all these different tests. There's the efficiency gap, and there's these partisan bias and asymmetry standards. All of them show Wisconsin's an outlier. And there's actually a brief filed by a molecular biologist, I think, who said, you police the outliers, basically. You can know, and so that maybe that's the job. So one of the cases I discussed in my 2003 book is Harper versus Virginia State Board of Elections. So this is a 1960s case. The United States had already passed a constitutional amendment that said that poll taxes in federal elections were unconstitutional. But as to state elections, that was still up in the air. There were 4 states left that still had a poll tax. It's really interesting what happened inside the court. Initially inside the court, it came up from a 3-judge court, so the court had to affirm or reverse. It couldn't just cert deny. Initially, it was a 6-3 vote to uphold the state poll tax, with Brennan in the majority, uphold the poll tax. And Justice Goldberg wrote a dissent, draft dissent, where he said, basically he had a theory of the protection clause that saw poverty as a suspect class. It was this very broad pronouncement. And Hugo Black, who was in the majority and really thought poll taxes were fine, said, I can't let this stand. We can't have this thing go out there unanswered. Let's have oral argument. And court holds oral argument. The next term, 3 justices change their vote. Instead of being 6-3, it becomes 3-6 for the poll tax. And I'm talking about, so there's 4 states left, and the hard question is, do you let the political process run its course, or do you come in there? And I say, there was enough of a social consensus that you get rid of the last outliers. And so that's where protecting the core and dealing with the outliers is what I'd like to see the court do. But I think that, just to be clear, I think some of the voting cases that have been brought by Democrats and the ACLU have gone too far. So for example, in 2008, then again in 2012, or maybe 2012 again in 2016, that's what it was. Ohio had, the Ohio Republican legislature had moved from having 35 days of early voting to 28 days of early voting. And when they moved for that 1 week less, they eliminated what was called golden weeks. There was this 7-day period where you could both register to vote and early vote at the same time. Democrats love that. One-stop shopping, drive people out, get them to it, and then you're done. And the argument was this violates the protection clause. And so 28 days of early voting is 28 more days of early voting than New York or Pennsylvania offers. So how could it be that cutting down to 28 days is somehow a protection violation? Now, there were some other arguments. The military voters had more time, but it seems to me that, you know, you can overuse the courts too for protecting these voter rights, and I don't think that all of these cases should end up in federal court. Yeah.
I guess I still resist your statement that the Supreme Court is a political court because there are other factors at work. I mean, we talk about the crossover voting, which we see, the fact that some justices are inconsistent, they change over time. Justice White couldn't be predicted, Justice Souter wasn't predicted. They think about the institution of the court every so often and try to protect that. And they also divide it by topic. You know, criminal law you don't always get these splits. So there are a lot of other pulls on the way that they think about cases and vote on cases, so that reducing it down to Democrats and Republicans or just a political institution seems to downplay all these other features. And I wonder how you respond to that.
Yeah. So I definitely think there's some truth to that, and I have a chapter in my upcoming book on criminal law where Justice Scalia was at his most interesting. Sometimes very tough on crime and kind of what you'd expect of a conservative justice, and sometimes not, very protective of, in the Fourth Amendment context, confrontation clause, sentencing. So I guess so there's some truth to that, but I think we're going to see less and less of that. So somebody asked me, they said, why is it that the right is so much more exercised about judicial nominations than the left? What can you do to make the left excited? And I said, just wait for Justice Kennedy to retire. Give it 2 years, and the left will be very excited. It'll be too late, but you know, I don't think we're going to see more Stevens and Whites and Souters. You know, the line about Neil Gorsuch from Dolly Lithwick was that he was, what was it? A Federalist robot straight out of, you know, Central Casting. I can't remember what, she had some, that you know, he was reliable. He's not evolving, as they say. And I really don't expect that he's going to evolve. And, you know, maybe the Democrats will put a Pam Carlin on the court next. But, you know, I don't think we're going to see more David Souters because the Republicans learned their lesson. And we're much more polarized now. Go back and look at, you know, who voted for Souter, even who voted for Roberts. Look at the Democrats who vote for Roberts. It's completely changed. The last 10 years, the Senate has become much more polarized. And if you've got now 50 votes and a vice president, you're just going to ram them through. The Republicans are playing hardball. I fully expect the Democrats are. And so while what you're saying is probably true historically, I think we're moving in a different direction now.
Please join me in thanking Rick. And I encourage anyone who's interested to come down for the last session of our symposium, which will start at 1:45 in the courtroom. Thank you.